And this leads me to this 1099A. Once again, I think I'm really lucky because I think I'm the only guy I know of in the country, a litigant that's going up against these crooked banks, that actually has one of these 1099As that I was able to obtain from the Internal Revenue Service in my possession and control. Now, anyone that doesn't have an accounting background, don't worry about it. Even the lay person can understand this, because the question in box 5, and anyone can go to the IRS website and look up a 1099A as an alpha. It says, was borrower personally liable for repayment of the debt? Yes or no? It's kind of like, are you pregnant or you not? Yes or no? And box 5, as you can see, is checked no. So a reasonable person has to ask themselves, if box 5 is checked no, stating to the Internal Revenue Service, borrower was not personally liable for repayment of the debt, then what in God's green earth is Shannon Menapace, one of Dore's crooked attorneys who has since left for another fraud closure mill law firm, doing, filing an amended statement of alleged quote-unquote debt, alleging over $550,000 alleged to be due and owing to the court, but yet the 1099A, filed with the Internal Revenue Service, says the exact opposite. Thomas Dore cannot authenticate a ham sandwich because he wasn't there, he has no first-hand knowledge.
Ladies and gentlemen, for those of you new to this, you're about to get an education. We're starting right now. The first thing you need to be aware of is that it seems perfectly legal out here in this climate for entities like Citibank to launder money coming from Mexican drug cartels, done with the explicit knowledge of our American government. That right here is a government document. Think about that. No one's gone to prison. We are living in a climate where everyone knows that the FDIC's own merger documents prove that Bank of America never bought countrywide pooled loans, and that Chase never brought the WAMU loan pools. Yet homeowners typically have no recourse as they make valid lack of standing, lack of first-hand knowledge, and valid real party and interest defenses to fraudulent foreclosures. Fortunately, there are rays of hope. In Illinois, the case of Neighborhood Lending Services versus Michael Henderson will likely end up in a settlement after judgment was reversed recently based on a lack of first-hand knowledge in the chain of title on the part of the foreclosing entity. You do a Google search and you'll see where I documented the Aurora servicing cases where courts have made the exact same determination, as it should be. Even in the judicially conservative state of Texas, we see where the court in McCarthy versus Bank of America denied summary judgment to Bank of America, then ordered them to produce the original documents, all of which naturally precipitated an immediate settlement because they have no original documents because they were destroyed, most likely, as the Florida Bankers Association has acknowledged. At a minimum, every homeowner deserves such a settlement, and in this video, we help to begin to educate you in order to show you why. How did this lawyer convince this judge
See the concepts up here, fraud closure, what is it, how is it committed, who are the players. These are real life examples that can show you what you see conceptually here is really happening. So you saw the other two pieces of evidence, the 1099A and the Florida Bankers Association admitting all notes are destroyed. Now this here, you might not be able to see it, this is testimony. I was fortunate, I say grateful, I got lucky 3 years ago, August 11th, 2010, to examine a fraud closure mill attorney, Thomas P. Dore, under oath 3 years ago. I got lucky that day. This is a transcript testimony. 3 years ago, Thomas Dore claimed to have brought, allegedly, the original note into court. And I objected right away because I knew it wasn't the original. Thomas Dore cannot authenticate a ham sandwich because he wasn't there, he has no first-hand knowledge. But I've got Thomas Dore's testimony here, allegedly authenticating the original note 3 years ago, and you just saw, everybody here just saw, the Florida Bankers Association admitted that all physical notes are destroyed. It is a virtual impossibility for Thomas Dore to have authenticated anything that day. He knows it, I know it, and the court knows it. And I want all of you to know this now too, because if you ever get lucky and you get a witness coming into court to try to authenticate some evidence, you show them that and say it doesn't make sense.
Yeah, and that's very key, because what happens is the more people do this and the more people get educated,
Right.
that's when you guys out here, you know, we want to start an avalanche, if
Yes.
you will.
Right.
And so when I was a title insurance producer during the heyday, the 2003 era, 2003, 2005, 6, that was a time when I was young and naive, and I wasn't that young, but I had no idea what was really going on. And I thought that when a LIBOR loan, for example, was made, that those were supposed to be premium loans, more guaranteed. And I come to find out that the LIBOR loans were, the information was all manufactured, and it was fraudulent. And these are things I learned in later life, in the last 5 years.
Okay.
And so I got involved with the project because I saw homeowners were being deprived of their basic rights through the court system. And I decided that it was something I had a background knowledge in, and it's something that I could do to help effectuate a change. And I brought my journalistic background. I've written for major press, I've written for medium press, I've edited, I've been a photojournalist, and I decided to bring that wealth of knowledge, along with my legal knowledge, to this arena.
Great.
In any event, these situations are serious, and Judge Norman, who I believe has ties to foreclosure mill attorney Thomas Dore's alma mater, couldn't care less about these issues. It flies in the face of Judge Wilner and the committee, and you'll see why momentarily.
Counsel, how many times has Mr. Dore been sanctioned?
And this goes to how is it committed. And you wonder how it's committed. Fraud closure is committed by bringing in fraudulent documents into court posing as original documents or copies of originals. And some of you in this group have different experience. You may or may not know that Lorraine Brown, the former president of DocX, that was the big document mill that supplied all the fraudulent documents to all the fraud closure mills. She admitted to being responsible for forging, fabricating, and or falsifying over 1 million documents, which means it's probably 10 times that much. She's in jail now. She had to take the fall.
Who is that lawyer right there? And what did he do with that bag right there that impugns the integrity of the Baltimore District Court? Simple. He brought a courtesy copy of a motion to dismiss on behalf of M&T Bank to Mickey Norman, who then turned around and completely lied about the intent, the focus, the purpose, the direction of Emergency Rule 14-2071 that was propagated in part by that man, of course, Judge of the Year. So, this all happens at a time when you have the highest foreclosure rate in the country in Maryland. This all happens at a time when the research of law clerks like Jose Portillo and me, and the homeowner in this case, are all designed to address this serious problem. And the problem is so serious that there are thousands of tainted deeds of trust throughout the state, and it's an epidemic problem. People are looking up, and cases are being thrown out because of these problems, as you can see here.
Is this the original? I don't know. Couldn't tell you because they never produced the original. And we always demand originals. I'm going to show you this.
And let's just stop for a second
Sure.
here, because when we say original, we mean that you guys out here, you consumers,
Correct.
need to be pressing them to have a document expert
Correct.
come up in there to the court or to an mutually agreed upon location with a jeweler's lens to do an analysis of that signature, because they make fake originals again, as we noted earlier. So this is what I'm talking about. What you're talking about, what we're here about,
Yes.
is that issue. Because in theory, what could really happen is Bank A could foreclose on you today, you could pay them off.
Correct.
And then tomorrow, another bank could show up with your alleged original note. And then where are you?
And I've had that happen where
Ladies and gentlemen, lest you underestimate the serious nature of this issue, please be advised that we are aware that Bank of America has patented a way to securitize and to basically make money off of your failed loan application on a 1003. This is the type of thing that you're fighting, and we have a network of attorneys, referral attorneys, who are here to fight for you, using various techniques, including quiet title actions, to get you on a better footing with the bank when you come to negotiating. So stay tuned for that, and please contact us, and we will put you in touch with these attorneys.
But remember, if you look at 1099 OID, it's an original issue discount. And it says in the OID who is the source of the funds and who is the recipient. You and I are the source of the funds due to our signature. So everybody's notes are functional money in this economy. There's no gold or silver backing our dollar, so notes with a live wedding signature are functional money.
And that's fine and good in a limited sense. However, when you go to foreclose on somebody, you better have that original note, that original mortgage, and all the assignments. Judge Arthur Shack will tell you that, and so will many others.
You ever got the actual OID that was filed with the IRS because they pulled your note, my note? You would see that the issuer is not who they say it is.
That's right.
We are the issuers. They're the recipient. In the trademark office, so we just do the patents. Maybe Bank of America can explain to us what value does a rejected loan application have? And matter of fact, more importantly, why would you syndicate, which means...
Well, it sounds like to me, Todd, what they're doing is selling off the denied application to a third party as far as the information is concerned.
That's right. And they got to have value to somebody because
Right.
they wouldn't be putting them together and pooling them
Absolutely.
if somebody wasn't buying them.
Because those are not application now becomes a product to sell off to someone. Oh, that now makes sense.
It's a security.
Absolutely.
Exactly. And it kind of changes the way you think about paper now, doesn't
Right.
it?
Absolutely, it does.
Because before that signature got on it, it was just a 1003 loan application.
Okay.
Worthless piece of paper. But the minute it got somebody's signature on it, that represented somebody's value. That's why the world derivatives market, which is 20 times,
to 30.
20 to 30 times world GDP.
That's right.
And it's
Now what happens is the banks try to foreclose on you, and they'll make up reasons. I have seen cases where they make up false escrows, any reason they can, to foreclose because they think that they can clean the whole thing up. And there's case law that says you can't do that. But in any event, once that chain of title is broken like that, when they try to foreclose, they cannot prove standing, they cannot prove that they're the real party in interest, but oftentimes the courts will let them proceed regardless.
Okay, so Mr. King, is it fair to say no contract, no case?
If you want to break it right down to that level, that's kind of it, and also they're forcing you into a trust,
Okay.
which you had no idea you were getting into when you signed up on that note. You didn't know that there was all these
absolutely.
factors were. You had no idea.
These are comments of the Florida Bankers Association. These are bankers, okay? The Florida bankers admitted that many times firms will file lost note counts because somebody had asked before about the note. A lot of times in Florida and many states, they claim they lost a note. Well, you're going to find out they didn't lose the note. They purposely destroyed it. Remember, this is comments from the Florida Bankers Association to the Supreme Court of Florida. It says right here, it is a reactive court case. Thank you, Florida Bankers Association. And the reason I share this with you is all of you out there that may or may not be dealing with fraud closure cases, if a bank tries to bring in or an attorney tries to bring in alleged original note, and you have this, and you show this to the judge, and you can show this to the attorney, say, can you please explain that to me? Because it says right here, bankers admit that all notes are destroyed. So how can you claim you have the original note?
And that's very key, Todd, because this gentleman here was just asking me a question about, well, what if, for example, the court wants to ignore that? Well, then that's when we're not here to be lawyers or to tell you exactly how to practice in any given case, but there's a thing that's known as, judicial notice of important things. And if the court is honest and has integrity, which we still find on occasion, it should require the moving party, which is the bank typically, to show that it does have an intact chain of title, free from fraud, and free from fraudulent documents. We've all seen these cases where there's more than one note in a file that shows up, and that's exactly why.
Correct. And you can do a lot about it. And I'm just going to do a quick overview of some of the things you can do about it. Most importantly, try to lose the stigma about it. Fraud closure, it's the reason I use that word, fraud closure. It's nothing to be embarrassed about. If you out there are going through it yourself or you know somebody who is, talk about it, be open about it. It's the first thing. Talk to your neighbors, politicians, the sheriffs. Remove that stigma of foreclosure, and that's why I use fraud closure. It totally shifts in your head how you think about things if you get rid of the word foreclosure. Approach the media. Media is really, really important. More and more media, independent journalists are coming around writing stories about it now. Approach the media, especially independent investigative journalists. They're some of your best allies out there. Judicial activism. Some people enjoy doing judicial activism and going out there and picketing and protesting. I personally, it's not my style. I do more on the educational side, but if you're an activist, do that. Educate others. This video was designed, this whole meeting was designed to educate all of you. Spread this education around and educate others.